my motto is that no one should be so intimidated by the law that they don't take the right steps to protect their family. So this stuff is not fun. The law, death, taxes, family squabbles, all kinds of things that are painful that people don't want to talk about. But it's better to face these things now rather than have trouble bubble up later to the surface, okay? The program today is called 5 Secrets of Estate Planning, okay? There are 5 things that people don't know but really ought to know. Estate planning scares people, right? And there are things you need to know, and we're going to go over 5 things that are really important. But the number one thing is really don't put it off, right? I mean, you never know what's going to happen, especially these days, and putting it off can be frightening for you and frightening for your whole family. Here's what we're going to cover today. 1 is a short introduction to me, then the 5 secrets, okay? The first one is intestacy. That means what happens to your estate if you don't have any plan at all? What happens to your property? Who's in charge? Intestacy are the state rules that govern that. We're going to talk about that first. The second is a surprise to some people. Your will does not cover all your property, only some of it. And you may be surprised to find out what it covers and what it doesn't. The third thing we'll talk about is interesting to a lot of people, and that's that it doesn't cover all the situations you would want covered. And it covers death. It doesn't cover incapacity. That means your will is only effective when you've passed away. But if you suffer from dementia, Alzheimer's, if you're in an accident and you're in a coma, your will doesn't play any role. You need another document or set of documents called powers of attorney. We'll talk about that because it's really important. In fact, powers of attorney, I think, sometimes can be even more important than having a will in place, because if you don't have a will, like we'll talk about first, there's intestacy. Okay? There are state rules in place that govern your estate when you're gone if you don't make a will. But it's a big problem if you have Alzheimer's or dementia and you don't have a document in place appointing an agent for you to handle your affairs. That can be very time-consuming, expensive, and messy. The fourth thing, which is interesting to a lot of people, I hear all the time from clients, well, we have a will, we don't ever go to probate, right? And that's not true. Having a will does not mean you avoid probate. In fact, it almost guarantees it, okay? So I'll talk a little bit about what that means and what probate is today too. That's the 4th surprise, or the 4th secret. And the 5th thing is that a trust is the vehicle that you use to avoid probate. And a lot of people are like, well, I'm not a Kardashian, I'm not Trump, I don't have $1 billion, I wouldn't need a trust. A trust is very useful if you have minor children, or you want to avoid probate for the people that come after you, your family. And we'll talk about how that works. It's a little complicated, but not that complicated. All right? But first we're going to talk about me, all right? That's my favorite subject. So who am I? I'm a practicing attorney in Gurnee. I grew up in Waukegan. Then I went to Carmel for high school in Mundelein. I went to the University of Chicago and graduated in '96. And then I graduated from the University of Virginia School of Law in '99. After graduating law school, I went to New York City. And I lived in New York City for 9 years, okay? I was there on September 11th. And that was a really interesting time to be in New York City. And I was in Midtown Manhattan when the planes actually struck the Twin Towers. In Manhattan, you could see the Twin Towers everywhere from the island. I mean, they were so big. I saw the plume of smoke. I asked a guy on the street, I was coming out of a Starbucks, I was like, what is that? And the guy was a New Yorker, and New Yorkers have this attitude about them, and he was like, forget about it. Some jerk just flew his plane into the building, like it happens all the time, right? And then the other one hit, and then they came down. And everyone from our office went to the Red Cross to give blood, and they turned us all away. And they turned us all away because no one really survived. They didn't need any blood. And it was a very unusual time to be there. and I met my wife there. And then after we had our second baby, shortly after that, we decided we would move back to Lake County. I always wanted to have my own practice. And New York was a really fun place to be when you're young and single. But once you start a family, New York City is no place for a family. It just isn't. And Lake County, I was thinking about moving home for a long time while I was working. But once we had our second baby, I was like, we're out of here. So I returned home. I started my own law practice. And just so you know, I have a TV show on Comcast called Everyday Law. It's on YouTube as well. You can watch the episodes there. And I do it for fun and for education for people and for practice. Then, like I said, I wrote a book kind of summarizing people's questions about estate planning because I thought it would be very useful to have that. And you can have one for free today. So once again, the 5 secrets we're going to go over today are 1, intestacy; 2, what a will does not cover; 3, key situations it doesn't cover; 4, that a will doesn't mean you avoid probate; and 5, how a trust works. Okay? Intestacy is the government's plan for you. Okay? So, intestacy, the laws of intestacy are a set of rules that are in place that are the legislature, the state legislature's best guess of what you would want if you died without a will. And the intestacy rules are okay, but they're the government's best guess, and they're not what you want. And they have problems, and the first of the problems is that you're not in control, right? It's a list. For example, who's your executor is a list, and it starts with your spouse, then your children, and then your other relatives going down a list. And they can all petition the court to administer your estate if you don't choose the person who you want to administer your estate. So someone you don't even know could be in charge of your things and what happens to you after you're gone, who you wouldn't even want to do that if they petition the court and they have the right priority. If you have children, minor children, the state could determine who's their guardian. Your will sets out who the guardian for minor children would be. There's a bond requirement that a will waive. What's a bond requirement? When you die, your executor, your administrator, if you don't have a will, has to buy insurance, an insurance policy on your estate. The person administering your estate has to pledge to the court that they won't steal from your estate and has to buy insurance 1.5 times the value of your estate from an insurance company, basically promising the judge and the court that they won't steal from your estate. A bond is usually waived by a will. That's one of the key things a will does that people don't even really know about. But your executor, after you're gone, is in a much better position if you have a bond waiver in your will than if you die intestate without a will. Also, the state tells you how your assets are distributed and to whom. And there's a lot of problems with it. The biggest problem, which is weird, nobody really understands this, but the distribution rule is that, okay, every will gives everything to the spouse if it's a married couple. That's what everybody wants. If you're married and the other spouse is alive, it's almost always the case that one spouse wants everything to go to the other spouse on the first spouse's death. Intestacy does not have that rule if there are children. If there are children on the death of one spouse, say the husband. The husband always dies first in our examples. Husband dies, all of his property doesn't go to his wife. Half goes to his wife if there are children. The other half go to the children and are split up among the children equally. Now that's weird. Nobody's ever explained to me why that is, but that is how it is. Now it's the husband's individual property that gets distributed that way, right? So if it's jointly owned, it goes directly to the joint owner, and we'll talk about that in a minute. But if it's the husband's individually owned property, it doesn't all go to his wife under intestacy. It gets split up between his children, one half, and his wife, the other half. So intestacy should be avoided if possible. And a will can be a simple thing to draw up. I think I was speaking to someone earlier who's drawn up a will on their own. I don't advise it, but it can be done. But to die without a will can raise a whole host of problems in terms of who's in charge, who gets what, the bond requirement, how your things will be divided, and you have no say over it when you're gone, okay? And you can't have say over it while you're alive, right? That was intestacy's worst default rule, the one about division between the wife, the wife and the kids. The next thing, which is strange to a lot of people, is they think, well, I've got a will, it disposes of everything, and it doesn't, okay? Key thing to know is that different assets, different categories of assets, pass differently on death, depending upon the type of asset it is. I'll say that again because it's kind of confusing. There are classes of assets. The classes of assets pass differently on death, depending upon the kind of asset. And only one kind of asset is a probate asset, and only probate assets are governed by your will. So there's 4 kinds, okay? The first kind of asset, the first class, is a jointly owned asset, right? Most of you who are married probably own your home jointly with your spouse. That's one kind of asset. When you die, it passes automatically to the other joint owner by operation of law. Probate has nothing to do with it. The probate court has no interest in jointly owned assets. Okay, that's the first kind, jointly owned assets, okay? The second kind of asset, beneficiary designated assets, life insurance policies, 401ks, pensions maybe, IRAs, anything with the benefit payable on death accounts, anything with the beneficiary designation, that's a contract where you've made with the party that when you die, that's a triggering event and the asset goes to the beneficiary. Also, not a probate asset, okay? It's a beneficiary designated asset, not a probate asset. Third, and we'll get to this at the end, are trust assets. Trust assets are owned by the trust. This is something we'll talk about at the very end, okay, because it's a little complicated, but it's owned by a trust and not an individual, so the probate court does not take an interest in it, okay? Lastly, anything else is a probate asset, okay? So it's owned by an individual at death, it's a probate asset. It's not jointly owned, it's not a beneficiary designated asset like a life insurance policy, and it's not in a trust. It's owned by an individual at death, it's probate property. I'd love to stop and ask for questions, but I can't. So if you have any questions, please hold them, because this is a little complicated maybe, and maybe this is the first time you've heard it, I don't know. But it's important to know that probate court does not take an interest in everything, only probate assets, and your will only disposes of probate assets. What that means is when you're planning your estate, you can't just write up your will and think that everything is done. You have to plan out, well, who are my beneficiaries? And if I make this person a beneficiary of this much under my IRA, well, what should I give how much of my probate assets should I give to my cousin or my child or whatever it may be? It can be complicated sometimes and sometimes not. I think there's one thing I wanted to say, and that was one time I saw a will where the will disposed of a beneficiary designated asset. And you have to know, it's the will that does not do its job, that's it. So the will purported to dispose of a life insurance policy or an IRA, I can't remember anymore what it was, but it was something that the will didn't control. And it's ineffective. It's like it doesn't even exist in the will when the will says, well, I give my IRA to Johnny. Well, it doesn't happen that way. Johnny doesn't get it through the will. If the beneficiary designation, of the IRA or the life insurance policy says it's Sue, Sue gets it, no matter what the will says. So you have to be very careful in planning an estate. You have to know a lot about moving parts, and then you'll be able to sort of plan it accordingly. You have to sort of look at all the assets you have, whether they're joint assets, beneficiary designated assets, maybe trust assets, and then probate assets, and figure out how you want them distributed. But you have to remember that your will doesn't control everything, only some of it. Okay? The next part I wanted to talk about is conditions a will doesn't cover. And people often think, well, I have my will, I'm done. But that's not the truth. What you need to have in addition to a will are powers of attorney. I don't know if anyone has had a chance to deal with those, but what a power of attorney does is appoint an agent to make decisions for you when you can't make them for yourself. There's two kinds. They come in two flavors. There's a power of attorney for property and a power of attorney for health care. And they're different. Power of attorney appoints an agent to make decisions about your property when you can't make them for yourself, when you can't make decisions for yourself. A power of attorney for health care appoints an agent to make health care decisions for you. The reason they're different is this. What they avoid are guardianships in court. Okay. If you don't have a power of attorney for health care or property, you have to go to court. If your relative is incapacitated by dementia, Alzheimer's, a coma, whatever it may be, you don't automatically have the right to make decisions for your closest relative, even a spouse, without a court order or a power of attorney. So what a power of attorney does, making you the agent, is gives you the right to make decisions without going to court and getting an order. Okay? It's a substitute for a court proceeding. If you don't have one, you have to undergo or engage in a lengthy court proceeding where there could be conflict. It's time consuming. It's way more expensive than a simple power of attorney. And the reason there are two flavors of powers of attorney are there's two flavors of guardianship. There's guardianship of the person, which basically a power of attorney for healthcare substitutes for, and there's a guardian of the estate, and that's sort of what the power of attorney for property substitutes for. And they're different kinds of guardianship. The court administers them differently, and that's why there are two powers of attorney. One for property, one for healthcare. Okay? Okay. The next thing to talk about is probate. Probate is something that people are scared of, and it's another court proceeding, and it's time-consuming and expensive and lengthy and complicated. And people think that if they have a will, well, that means they don't go to probate court. And unfortunately, that's not true, okay? Your will is an interesting document. Your will is a document that's not effective until a triggering event. And that triggering event is your death, okay? It doesn't mean anything until you've passed away. You can change it, you can revoke it, you can do whatever you want with your will. But once you've passed away, then it becomes effective. However, it doesn't become effective on its own. It needs a court proceeding to become effective. The simplest example is this. If you pass away and you appoint Sue to be your executor, and you have a bank account, and Sue takes your will to the teller where you have your bank account and says, I'd like to withdraw the funds so I can distribute them to me and Johnny, the two children, the bank teller will say, well, I don't want to see the will. I want to see letters of office issued by a court. The will has no effect till it's approved by the court. So Sue, the executor, would have to take the will to court. And that's the probate court in Lake County in Waukegan, okay? The judge there is Judge Elizabeth Rochford, very nice lady. I'll plug her, she's running for Supreme Court. And she's the probate judge. Now, she has to approve the will. Sue goes in with her lawyer. The lawyer goes by himself and tells the judge, look, judge, this is the will. It appoints Sue the executor, and all the formalities are followed and bond is waived and so on. And the judge looks at the will, examines it to make sure all the formalities are followed, and if she approves of it, 2 weeks later she issues letters of office to Sue. Then Sue can take those to the bank and get the money from the bank, from the teller. Okay, and then the teller will be satisfied. A teller can rely on letters of office to release funds, okay, but not a will, because a will's not effective by itself. It needs court approval. Once it gets that court approval, though, you're in probate court and you're under the jurisdiction of the probate judge, okay? And the probate judge has to be satisfied about everything that's going on with the administration of the estate, all right? Whether it's sort of dispersing money to the heirs or collecting assets or paying debts or whatever it is, the probate judge takes an interest in everything. And that's probate. And so will does not avoid probate. It's not effective on its own. It's almost a certainty that if you own a certain level of property and you have a will, you'll be in front of the probate judge. That's not a terrible thing. She's very nice, but there are ways to avoid it, and that's what a trust is. Okay, I got 5 minutes to explain a trust, and it's not so complicated. Let me get there. Hang on a minute. A trust is, well, let's just talk about what a probate avoidance trust is, okay? Do you remember when I said that there are 4 kinds of property? Jointly owned property, beneficiary designated property, probate property, and trust property. Probate property is everything you own as an individual when you pass away. The trick about trust property is that it's technically not owned by you as an individual. When you create a trust, bear with me, you own the property in the trust as the trustee of a trust. Okay. A trust is like a bowl that holds property. You create it, you fill the bowl, and everything in that bowl is outside the jurisdiction of the probate court, so the probate court has no authority over it. Okay. A trust is an agreement. Okay. Trust is an agreement between 3 people. There's the grantor who gives the property. There's the trustee who takes it and manages it. And then there's the beneficiary who gets the property when the trustee gives it to the beneficiary. Sometimes these are created for children who have problems handling money. Sometimes they're created for minor children. The trick about probate avoidance trust is this. Okay, let's just say this is the deal. Is there a woman named Rose here? I thought there was a Rose I met. I'm sorry. Okay, great, you're Rose. Sorry. I don't mean to embarrass you. But let's say I have $10,000, okay? I have $10,000 and I give it to Ed. I'm the grantor, okay? But I give it to Ed as a trustee. And I say, Ed, under this agreement, you have the obligation to handle this money on behalf of Rose, who's the beneficiary of the trust, okay? So I'm the grantor. Ed, you're the trustee. It's not your money. You're just holding it for Rose, and she's the beneficiary. And Rose, you're the beneficiary, okay? Grantor, trustee, beneficiary, typical trust. Probate avoidance trust, you are wearing all 3 hats at once. You're the grantor, the trustee, and the beneficiary all at once. You give yourself your own property to manage for your own benefit. Why would you do that? Because it gives you a new identity as a trustee. It's like Batman and Bruce Wayne, okay? You are a trustee now because you have a trust, and you have an identity as an individual, okay? So anything you place in the trust by deeding over to the trust or putting the trust name on is owned by the trust. Now you're still managing it. You've created what's called a revocable living trust. And anything in that trust is now outside of the jurisdiction of the probate court. So you have these 2 identities. One is an individual, one is a trustee, and anything in the trust bucket is outside of the court's jurisdiction, so you don't have to worry about probate for anything you put in there. Okay? So if you hold things in trust, jointly, or with beneficiary designated accounts, you never have to go to probate. And that is the trick of a trust. And let me see if there's anything else to say about it. I don't think there is. I'm about a minute to go. So just in conclusion, I want to thank you all for coming. It's been really fun to present to you. I hope I've raised some questions during the presentation. We are going to have a half hour of questions now off camera. And thank you again.